Good morning, ladies and gentlemen. This is Kunale. Today we are going to read about the legal services and Lok Adalat, Chapter 16. Chapter at a glance. Legal aid is the provision of the assistance to people otherwise unable to afford legal representations and access to the court system. Article 39A of the Constitution of India provides that states shall ensure that the operation of the legal system promotes justice on the basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disability. The enactment of the Legal Services Authorities Act 1987 was a significant step to provide free and competent legal services to the weaker section of the society to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. National Legal Service Authority, State Legal Services Authority, District Legal Service Authority, and Taluk Legal Service Authorities were the main authorities which are constituted under the Legal Services Authority Act 1987. The main function of these authorities is to frame the most effective and economical schemes for the purpose of making legal services available under the provision of this act, organizing legal aid camps, especially in rural areas, slums, or labor colonies, with the dual purpose of educating the weaker sections of the society as their right, as well as encouraging the settlement of disputes through Lok Adalat, are also very involved. Lok Adalat means people's court. This is a system where people can solve their disputes or problems on the basis of conciliation or negotiation. If an aggrieved person will go court to get justice, he or she has to be spend lot of time and money. Lok Adalat system will save the time as well as money as the aggrieved. Every state authority or district authority or Supreme Court Legal Services Committee or very High Court Legal Services Committee or Taluk Legal Services Committee may organize Lok Adalats. Lok Adalats are to consist of 3 members: a sitting or retired judiciary officer, a member of the legal profession, advocate, law officer and law teacher, and social worker, preferably women. After the settlements done in the Lok Adalat, an award is made which is deemed to a decree of a civil court. It is to be written down in simple and clear terms. There is no appeal against the award delivered by Lok Adalat. If no compromise is reached, the same goes back to the court. A plea bargain is an agreement between the prosecutor and defendant in which the defendant agrees to plead guilty to some of the charges or a lesser charge in exchange for a reduced sentence or some other concession by the prosecution. Plea bargaining can be defined as a pre-trial negotiation between the accused and the prosecution, during which the accused agrees to plead guilty in exchange for certain concessions by the prosecution. It gives criminal defendants the opportunity to avoid sitting through a trial risking and a conviction on the original more serious charge. The primary jurisdiction for plea bargaining are that: first, courts are overcrowded. If you don't allow plea bargains, courts would be overwhelmed and forced to shut down. Second, prosecutors' caseloads are also overloaded. Fewer trials means that the prosecutor can more effectively prosecute the most serious cases. Defendants save time and money by not having to defend themselves at trial. These court justifications also provide benefits to the court, the prosecutor and the defendant. Plea bargaining may be divided into the 3 broad types. First, charge bargaining, sentence bargaining and fact bargaining. Initially, the Supreme Court may be in favor of the concept of plea bargaining. By the government found it comfortable due to long list of pending cases before the criminal courts may cite it as a reason for the enactment of this provision. If a person accepts his guilt, then the time of the prosecution is saved which can be then properly utilized for providing more serious offences. Plea bargaining is applicable only in respect of those offences for which punishment or imprisonment is up to period of 7 years. It does not apply where such offences affects the socio-economic condition of the country or has been committed against women or committed against child below the age of 14 years. Plea bargaining helps the court and the state to manage the caseloads. It reduces the workload of prosecutor, enabling them to prepare for the gravest cases by leading the petty offences to settle through plea bargaining. It is also factor in re-informing the offenders by affecting the responsibility for before the law without having an expensive and time-consuming trial. In text question 16.1. Question 1. Why do we need Lok Adalats? Discuss briefly the statutory foundation of Lok Adalats. In our country, a large percentage of the people are illiterate and poor as they can't take the benefits of the legal processes as Indian judicial system is extremely expensive and delaying. So a different system of courts is created by a new law, which is called the Lok Adalat. Lok Adalat settle dispute through conciliation and compromise. Lok Adalat system have saved the time as well as money of the aggrieved. So it is favorable to a poor section of the society. Under Article 39A of the Constitution of India, the Parliament has enacted the Legal Services Authorities etc. 1987 with the legislative intent of constitute various legal services and authorities to provide free and competent legal services to the weaker sections of the society to ensure that opportunities for securing justice are for denied to any citizens by reason of economic or other disabilities. Lok Adalats were established for promoting justice on the basis of equal opportunity. Question 2. Have you ever attended any Lok Adalat which have conducted in your district? If yes, then tell your experience. No, I have not attended any Lok Adalat. In text question 16.2. Define plea bargaining. Plea bargaining can be defined as the pre-trial negotiations between the accused and the prosecution during which the accused agree to plead guilty in exchange for certain concessions by the prosecution. It gives criminal defendants the opportunity to avoid provides a sitting through a trial risking and conviction on the original more serious charge. For example, a criminal defendant charged with theft charge, the conviction of which would require imprisonment in state prison, may be offered the opportunity to plead guilty to a theft charge which may not carry jail terms. Question number 2. List various types of plea bargaining. Plea bargaining may be classified into 3 broad categories. First, charge bargaining. Charge bargaining is a common form of plea involving a negotiation of the specific charges or crimes that the defendant will face at trial. Usually, the defendant pleads to a crime that is less serious than the original charge or that the most serious of the charges. Example, the prosecution charges Andrew with burglary but the pleads guilty to trespassing. The prosecution dismisses the burglary charge. Second, sentence bargaining. The defendant takes a guilty or no contest plea after the side agree which sentence the prosecution will recommend. It saves the prosecution the necessity of going through trial and proving its case. Example, Max agrees to plead on the charges of the misdemeanor resisting arrest and the prosecution agrees to recommend that the judge not sentence him to jail time. Fact bargaining. The defendant pleads in exchange for the prosecutor's stipulation that certain facts lead to the conviction. The omitted facts would have increased the sentence because of sentencing guidelines. Example, the government files an indictment against Cole of drug trafficking. Federal against caught him with the over 5 kilograms of cocaine. 5 kilogram triggers a sentence involving many years in prison. So Cole agrees to plead guilty to the offense in exchange for the prosecution's stipulation that he possessed less than 5 kilograms. Thank you and thank you so much. I really appreciate that. Kindly subscribe to this channel. Thank you.